the Study for the Bar in Your Car podcast.
We're your hosts, Claude and Ma.
And this is deep dive number 9, focusing on evidence. We're doing a big evidence wrap-up and review today.
And for this deep dive, we're actually using the source material that, well, that brought us to life.
That's right. We are AI bots, animated by the magic of AI, and Angela's really, really thorough evidence note.
Brought to life. You know, it almost feels real sometimes.
Doesn't it? Like, wasn't there that J-Lo song, I'm Real? That was such a jam.
Oh, yeah, definitely. And the remix, you know, with Ja Rule.
Yes.
Classic. Gotta love the whole Jenny from the Block vibe.
Totally. It really makes you feel. Because I'm real.
Okay. Yeah, maybe stick to podcasting.
All right, message received. Okay, let's get back to evidence.
Right, but first, we absolutely have to give a huge thank you to Angela.
Yes, Angela. She's a real person, a law student, and she generously gave us her amazing evidence notes. They're the foundation for this whole deep dive.
Absolutely. These notes are, our roadmap through evidence for this review. Angela couldn't actually be here with us today.
No, she's busy doing law student things. Catching up on some serious work, apparently.
Which brings us to something else about Angela.
Oh, yeah. She works as a freelance law clerk, built up some good experience helping attorneys out.
That's right. So if you happen to be an attorney, or maybe you know one, who needs some help on an ad hoc basis.
Things like drafting motions, complaints, appeals, briefs. That kind of legal writing and research support.
Angela's available for that.
You can reach her by email. It's hello@legalwriterandlawclerk.com.
We'll repeat that at the end, too.
Okay. So let's dive into part 2, the lessons.
Our mission today is to take Angela's notes, which are really comprehensive, and pull out the key stuff. The core concepts, common traps, those crucial distinctions you need for exams like the bar.
Think of this as like a focused tutoring session using her notes, pulling it all together.
Oh, yeah, it's kind of sad we're wrapping up evidence. It's been quite a journey through these rules.
It really has. But don't worry, these ideas pop up elsewhere, and we've got tons more topics lined up for future deep dives.
True. So for now, let's focus on consolidating evidence. We're using Angela's outline as our guide for this big wrap-up.
Perfect. Let's get started. So right at the beginning, what's the absolute foundational thing from the notes about evidence law, especially thinking about the MBE?
Okay, the absolute first thing, according to these law school notes, is knowing which rules actually apply. Generally speaking, it's the Federal Rules of Evidence, the FRE. That's what governs on the MBE.
FRE is the default.
That's your baseline, yeah.
But the MBE loves traps, right? I've heard that.
Oh, definitely. And here's a huge tip, right from Angela's notes. A lot of wrong answers on the MBE. They often reflect older common law rules, the ones the FRE specifically replaced. So if you see an answer choice that sounds like some old-fashioned restriction, you need to stop and think, wait, did the FRE modernize this? Is it more permissive now? That's a classic trick.
That's a great tip for spotting wrong answers. Is it always the FRE in federal court, though? Any exceptions?
The notes point out a small but really important exception. Federal courts do sometimes apply state law. The big one you'll likely see is testimonial privileges.
Privileges.
Right. Specifically in civil cases, where state law provides the rule of decision. That's your classic Erie Doctrine situation.
Diversity cases.
Exactly. So while the FRE usually governs things like relevance or hearsay, you absolutely have to switch to state law for privileges in diversity cases.
Got it. FRE usually, but state privilege law in diversity cases. Okay, so we know the rules. Now, how does evidence actually get presented in court? What even is evidence, legally speaking, based on the notes?
Well, the notes define it pretty broadly. Basically anything that tends to prove or disprove an alleged fact. That includes witness testimony, documents, physical objects, the whole range. The notes categorize them, too. Testimonial evidence is what witnesses say, documentary is writings or recordings, and real evidence is the actual physical stuff, like a weapon or fingerprints.
And who gets to decide what the jury actually sees or hears? That brings up preliminary questions of fact, doesn't it?
Exactly. The judge has a really crucial gatekeeping role here. The judge decides those preliminary questions of fact that determine if evidence is even admissible.
Like what kind of questions?
Things like, is this witness competent to testify? Does a privilege apply here? Is this document properly authenticated?
Okay.
And here's something interesting the notes highlight.
Yeah.
When the judge is making these admissibility decisions, they're generally not bound by the rules of evidence themselves.
Really?
Yeah, except for privileges. They still have to follow the rules about privilege. but otherwise they can consider information the jury wouldn't normally hear.
So the judge can look at stuff the jury can't, but privileges still hold.
Pretty much. Things like whether hearsay is admissible or if a confession was valid, that's all for the judge. And the notes say these decisions often happen outside the jury's hearing, obviously, to avoid prejudice.
Makes sense.
And here's a key bar exam tip from the notes, like flagged with big letters, FRE 605. The judge presiding over the trial, they cannot testify as a witness in that same trial, period.
Cannot testify.
And the notes say it's so fundamental that an objection is considered automatic. You don't even need to object to preserve that error for appeal.
Automatic objection for the judge testifying. Wow. Okay, so what's the jury's role versus the judge's then?
The jury is the ultimate fact finder. Their job is to weigh the evidence, decide how credible it is, how reliable, but only after the judge has ruled it admissible.
Okay.
The notes also talk about jurors as witnesses under FRE 606. Generally, jurors can't testify in the trial they're serving on, but here's a distinction the notes make. Unlike the judge testifying, if a juror tries to testify, you do need to object to preserve the issue. It's not automatic.
Oh, okay. Judge is automatic. Juror needs an objection.
Right. And jurors also generally can't testify about what went on during deliberations after the verdict. There are narrow exceptions, like if there was improper outside influence or extraneous information brought in, or a mistake on the verdict form. But they can't talk about their own thought processes or the back-and-forth discussions.
That difference in objections is a subtle but important detail. Okay, what if someone tries to introduce evidence and the other side thinks it shouldn't come in?
Objections, that's the mechanism. To challenge the admission of evidence on appeal, you need to make a timely objection right when the evidence is offered. And you have to state the specific reason, the distinct grounds for why it's inadmissible.
Be specific and timely.
Exactly. Or, if it slips in before you can object, you make a motion to strike.
And what if you're the one trying to get evidence in and the judge says no, excludes it? How do you preserve that issue?
You make an offer of proof. The notes detail what this involves. You have to show the court what the evidence is, either present the document or describe what the witness would have said. Then you explain why it's relevant. And finally, you make your legal argument for why it should be admissible under the rules.
So you're basically creating a record for the appeals court, showing them what was kept out, why it mattered, and why the judge was wrong.
That's exactly it. If you don't make a timely, specific objection or a proper offer of proof, you generally waive the right to complain about it on appeal. Unless it's plain error, something really obvious and fundamental the judge missed.
Okay, you got to tell the judge what the issue is. Let's shift to some specific tools the court uses. Judicial notice.
Right, judicial notice. That's when a court accepts a fact as true without formal proof.
Why would they do that?
Because the fact is either really commonly known in that area, like everyone knows Chicago's in Illinois, or it's something that can be easily and accurately verified from a reliable source, like checking a calendar for the date of a holiday or a map for a location.
Okay, common knowledge or easily verifiable facts. How does this work with the jury? The notes mention a key difference between civil and criminal cases.
Yes, absolutely. This is a classic bar exam point. In civil cases, if the judge takes judicial notice of a fact, they must instruct the jury to accept that fact as conclusive. It's settled. Done.
Must accept it in civil.
But in criminal cases, it's different. The judge must instruct the jury that they may or may not accept the judicially noticed fact as conclusive. It's permissive. The jury can still disregard it.
Wow, that's a big difference. Seems like it protects the defendant's rights in criminal trials.
Exactly. It protects the right to have the jury find every element beyond a reasonable doubt. The notes also mention that while a court can take judicial notice on its own, usually a party needs to formally request it if they want to rely on it.
Okay. Speaking of things the jury might accept, what about presumptions?
Presumptions mostly come up in civil cases. The idea is, once a basic fact is proven, the jury can, or sometimes must, depending, draw a conclusion about another related fact, the presumed fact. Angela's notes talk about mandatory versus permissive presumptions or inferences.
Is there a really big rule about presumptions for the bar exam?
Yes, a huge one, the Nooks flag. Mandatory presumptions are not allowed in criminal cases if they shift the burden of proof on an element of the crime to the defendant.
Can't use a presumption to make the defendant disprove part of the crime.
Exactly. That violates due process. The prosecution has to prove every element. However, permissive inferences are generally okay in criminal cases, as long as the inferred fact is more likely than not to flow from the basic proven fact.
Makes sense. Prosecution carries the burden.
Right. The notes also briefly mention Erie again here in diversity cases. Federal courts give state presumptions the same effects state law would.
Okay, no mandatory criminal presumptions. How much control does the judge have over just running the trial, the flow of things?
A lot. FRE 611A gives the court reasonable control over the mode and order of examining witnesses and presenting evidence. The notes offer a really useful bar exam tip here. Trial courts generally have very broad discretion in managing the trial.
So assume the judge can probably do it.
Pretty much. If a question describes the judge directing how things proceed, it's likely okay unless there's a specific federal rule of evidence that explicitly says they can't do that.
Broad discretion unless a specific rule forbids it. Good heuristic. What about keeping witnesses out of the courtroom while others testify?
That's witness exclusion, or sequestration, under FRE 615. If a party requests it, or even if the court decides on its own, the court must order witnesses excluded so they can't hear what other witnesses say.
Must exclude if requested. Are there exceptions? People who get to stay?
Yes, Angela's notes list the main ones. A party who is a natural person, obviously, gets to be there for their own trial. A designated representative of a party that isn't a natural person, like a corporation, picks someone, or the government often designates the lead police investigator in a criminal case. The notes use that police officer example.
Okay, the officer in charge.
And third, anyone whose presence is essential for presenting a party's case. The notes give an example of, say, an expert who needs to hear the testimony to form their opinion, or maybe a summary witness in a really complex financial case.
So parties, their designated reps, and essential people can stay. Everyone else, out if requested. Okay, let's pivot to the absolute core of admissibility. Relevancy.
Relevancy. The first hurdle every piece of evidence must clear. FRE 401 defines it. Evidence is relevant if, 1, it has any tendency to make a fact more or less probable than it would be without the evidence.
Any tendency at all, even a little bit.
Yes, it's a very low bar. And 2, the fact it tends to prove or disprove must be of consequence in determining the action, meaning it has to be a material fact in the case. The notes use a basic contract example. Evidence is relevant if it makes contract formation slightly more or less likely, and formation is a key issue.
Low bar. Any tendency regarding a material fact. And the general rule, FRE 402, is that relevant evidence comes in.
That's the starting point. Relevant evidence is admissible unless some other rule keeps it out of the Constitution. A federal statute, other evidence rules, Supreme Court rules. Exclusion is the exception. Admissibility is the default for relevant evidence.
Which brings us to the big reason relevant evidence does get excluded, FRE 403.
Ah, yes, Rule 403, the big balancing act. Relevant evidence may be excluded if its probative value, its usefulness in proving the fact, is substantially outweighed by certain dangers.
What dangers?
Unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence, just repeating the same point over and over.
And the key phrase there is substantially outweighed. It's not enough that there's some prejudice. It has to be substantially more prejudicial than helpful. What counts as unfair prejudice?
Good question. Angela's notes define it as evidence that risks tempting the jury to decide the case on an improper basis, usually an emotional one, instead of using logical reasoning based on the evidence related to the actual issues.
So it's not just evidence that hurts the other side's case.
No, it's evidence that hurts their case in an unfair way by appealing to bias or distracting the jury. The notes use the example of bringing up an unrelated prior assault conviction in a new assault trial. Its probative value might be tiny, but the risk the jury just thinks, bad guy must have done it again, is huge. That unfair prejudice substantially outweighs.
Okay, that makes sense. Preventing emotional or irrational decisions. Beyond this general 403 balancing, there are specific categories of relevant evidence excluded for policy reasons, right? Article 4 rules.
Yes, these rules keep out certain relevant evidence because we as a society want to encourage particular behaviors, and admitting this evidence might discourage them. The notes explicitly mention the policy goals.
Like liability insurance, FRE 411.
Exactly. Evidence that someone had or didn't have liability insurance is inadmissible to prove they were negligent or acted wrongfully. Policy. We don't want juries thinking, oh, they have insurance, they must have been careless, or they don't have insurance, let's find them liable.
Can insurance evidence ever come in?
Yes, for other purposes. The notes list them, proving ownership or control, but only if that's actually disputed, or impeaching a witness, maybe showing bias if the witness works for the insurance company. And the notes give an example. If someone blurts out an admission like, "Don't worry, my insurance will pay for everything," and you can't really separate the admission of fault from the insurance part, the whole statement might come in.
Okay, not for fault, but maybe for ownership, control, bias, or inseparable admissions. What about fixing something after someone gets hurt? Subsequent remedial measures.
FRE 407. Evidence of measures taken after an injury, which would have made the injury less likely if taken earlier, is inadmissible to prove negligence, culpable conduct, a product defect, or a need for a warning.
Like fixing the broken step after the fall?
Right. The policy is clear. We want people to make things safer without fearing that the fix itself will be used against them in court as an admission of prior fault.
Are there exceptions here too?
Yes, similar logic. The notes say SRMs can be admitted to prove ownership or control, if disputed, or the feasibility of precautions, if the defendant claims it was impossible or too difficult to make it safer, and then they went ahead and did it easily. Or for impeachment.
Okay. Encourage safety fixes, but allow the evidence if they deny ownership or feasibility. Next up, settlement talks. Compromise offers.
FRE 408. This covers compromise offers and negotiations. Evidence of offering or promising valuable consideration money, usually to settle or try to settle a disputed claim, is inadmissible to prove liability for or invalidity of the claim or its amount. Also, conduct or statements made during those negotiations are generally inadmissible.
Why is disputed claims so important here?
Absolutely critical. Rule 408 only kicks in once there's an actual dispute about liability or amount. The notes have a great example. Someone gets bitten by a rat at a fair. Right after, before any lawsuit or formal claim, the owner offers $100 saying they feel bad. That offer might not be protected by Rule 408 because at that instant there wasn't necessarily a disputed claim. It might just be an admission.
So the timing and context matter. Has a dispute actually arisen?
Yes, and the rule generally protects statements of fact made during the negotiation, too.
What about negotiations with the government? Is there a special rule?
There is. The notes mention an important exception. Statements made during compromise negotiations with a government regulatory agency might still be admissible in a later criminal case. The example is incriminating statements made during civil SEC settlement talks being used in a criminal mail fraud trial.
Whoa, that's a big carve-out. Okay, what if someone just offers to pay medical bills, not settle the whole claim?
That's FRE 409. Offers to pay medical, hospital, or similar expenses resulting from an injury are inadmissible to prove liability for that injury. The policy is humanitarian. Encourage people to help with bills without fear of it being used as an admission of fault.
How is this different from Rule 408 settlement offers?
Key distinction the notes highlight. Rule 409 only excludes the offer to pay the expenses. Any accompanying statements of fact, like, "I'm so sorry I ran the red light, let me pay your hospital bill," are not excluded by Rule 409. That apology part might come in as a party admission, even though the offer to pay the bill itself is excluded. Rule 408 generally excludes conduct and statements made during negotiations.
So Rule 409 is narrower, just the offer to pay medical is out, but surrounding admissions might be in.
Correct. Finally, in this policy group, plea negotiations under FRE 410. Withdrawn guilty pleas? Pleas of nolo contender, no contest, statements made during the proceedings about those pleas, and statements made during plea discussions with the prosecutor that don't result in a guilty plea or result in one that's later withdrawn, all inadmissible against the defendant.
Seems like it encourages defendants to explore plea deals without worrying those discussions will be used against them if they go to trial.
Exactly. It facilitates plea bargaining.
Okay, those are the big policy exclusions. Now, let's tackle character evidence. Often tricky.
Definitely tricky. Character evidence refers to a person's general disposition or traits like honest, violent, careful. The fundamental rule, FRE 404A, is the propensity ban. Character evidence is not admissible to prove that a person acted in conformity with that character trait on a specific occasion.
You can't say he's a known liar, so he must have lied on the contract.
Exactly.
Yeah.
The notes use the example. You can't introduce evidence someone is generally a careless driver to argue they must have been careless in this specific accident. The worry is unfair prejudice the jury might convict based on perceived bad character, not the actual facts of the event.
So the general rule is no propensity evidence. When can you use evidence of someone's character or, more commonly, their prior acts?
That's FRE 404B. Evidence of prior crimes, wrongs, or other acts isn't admissible for propensity, but it is admissible for other non-propensity purposes.
The mimic rule.
Yes, the classic mnemonic. Motive, intent, absence of mistake or accident, identity, like unique modus operandi, common plan or scheme, knowledge, opportunity. The notes clarify this isn't just prior acts, subsequent acts can also qualify.
Subsequent acts, like what?
The notes mention, for instance, if a defendant threatens a witness after the crime, that threat might come in not to show they're a threatening person generally, but to show consciousness of guilt or knowledge about the crime.
Ah, okay.
The notes also talk about intrinsic evidence acts that are so intertwined with the charged crime they're needed to tell the whole story. Not quite 404B, but still subject to 403 balancing. The example was prior attempts to sell faulty equipment being part of the narrative in an aviation fraud case.
Part of the story of this crime.
Okay.
Does the prosecution have to give notice if they want to use this 404B, Steve?
In criminal cases, yes. If the defense requests it, the prosecution has to provide reasonable pretrial notice about the general nature of any 404B evidence they plan to use. Gives the defense a chance to prepare or challenge it. The notes point out there's no similar notice requirement in civil cases.
That's a key procedural difference. What's the standard for getting this 404B evidence admitted?
Two main things, according to the notes. First, there needs to be enough evidence for a jury to find by a preponderance, more likely than not, that the defendant actually committed the prior act. Second, and crucially, the court must do a Rule 403 balancing. Does the probative value for the specific MIMIC purpose substantially outweigh the risk of unfair prejudice? The risk the jury uses it for propensity anyway.
And often a limiting instruction.
Yes, if it's admitted, the judge should instruct the jury to consider it only for the specific non-propensity purpose, like intent or knowledge, and not as evidence of bad character. The notes give examples: prior drug sales to show intent to sell current drugs, or Lizzie Borden's prior knife antics to show intent or lack of accident.
Okay, prior acts for MIM can make subject to balancing and instruction. Now, if character evidence is somehow admissible, which is rare, how do you prove it? FRE 405.
Right. If character is admissible, like when it's an essential element of the claim, or a criminal defendant opens the door by offering evidence of their good character, the method depends. On direct examination, you generally use reputation testimony, what the community thinks, or opinion testimony, what the witness personally thinks based on knowing the person.
Not specific acts.
Generally not specific instances of conduct on direct, unless character is an essential element of the charge, claim, or defense itself.
What's an essential element?
It's where the character trait itself is part of the legal definition of the claim or defense.
Mm.
Think defamation cases, plaintiff's reputation, or negligent entrustment, person's known recklessness. It's pretty rare. In those cases, the notes say you can use specific instances.
Okay. What about cross-examination?
On cross-examination of a character witness, someone who just gave reputation or opinion testimony, you can ask about relevant specific instances of conduct. The purpose isn't to prove the act happened, but to test the witness's knowledge and credibility. The notes give the classic example. Defense calls a witness who says the defendant has a great reputation for honesty. On cross, the prosecutor asks, "Have you heard he was arrested for forgery last year?" It tests whether the witness really knows the reputation or what the community standards are.
Got it. Specific acts usually come up on cross of a character witness.
Right. The notes also mention the specific scenario in criminal cases where the defendant can offer evidence of a pertinent good character trait, like peacefulness in an assault case, via reputation or opinion. If they do that, they open the door, and the prosecution can rebut with evidence of the defendant's bad character for that trait, and sometimes offer evidence of the victim's good character for the same trait, if relevant, like in self-defense cases.
Okay, that's character. How is it different from habit evidence?
Habit, FRE 406, is very different and much more readily admissible to prove conduct. Habit is a person's regular, almost automatic response to a specific recurring situation. Think frequency and particularity. Business routine is the same idea for an organization.
So not a general tendency, but a specific, repeated behavior.
Exactly. Evidence of habit or routine practice is admissible to prove that the person or organization acted in conformity with that habit on a particular occasion.
Can you give the example from the notes?
Yeah, the Bob brushing his teeth example. If Bob is sued for not brushing his teeth on Tuesday, evidence that for 5 years, Bob always brushes his teeth for 2 minutes right after his morning shower is admissible habit evidence. It suggests he likely brushed them on Tuesday. But evidence that Bob has a reputation for being very clean, that's inadmissible character evidence if offered to prove he brushed his teeth.
Habit-specific repeated action, admissible for conduct. Character general disposition, usually inadmissible for conduct.
Precisely. The notes also say an organization's routine practice, like standard office procedure for mailing letters, is admissible to show the procedure was likely followed on a specific occasion.
That distinction is super helpful. Are there other times specific instances of conduct might come in besides MIMIC or habit?
The notes mentioned a few other contexts. Prior similar conduct by a party might be used to show their intent or motive currently. The example was Bruce Khan's history of not hiring women, potentially showing discriminatory intent in Marta's lawsuit.
Okay.
Sales of similar property nearby can be used to prove property value. Evidence that might not meet the strict similarity requirement for other purposes could be used to rebut a claim of impossibility, like showing nearby homes were damaged by blasting to counter the defendant's claim it couldn't have damaged the plaintiff's home,
Interesting.
and showing the industry standard of care by demonstrating how other companies in the field act is also relevant. The example was showing other lawnmower makers use blade guards as evidence of the standard of care.
What about the plaintiff's accident history?
Generally inadmissible character propensity evidence, but the notes suggest a very narrow possibility if it's to show something like a fraudulent scheme by the plaintiff. Very limited.
Okay. Let's shift to a really sensitive area now. Evidence about a victim's past sexual behavior. The rape shield rules.
That's primarily FRE 412. The general rule is extremely protective of alleged victims. Evidence of a victim's other sexual behavior or alleged sexual predisposition is generally inadmissible in both criminal and civil cases involving sexual misconduct.
Strong policy reasons behind that.
Absolutely. Protect victims, encourage reporting, prevent trials from becoming about the victim's past instead of the defendant's alleged actions.
Are there any exceptions in criminal cases?
Yes, but they are very narrow, listed in FRE 412b1. You can introduce specific instances of the victim's sexual behavior to prove someone else was the source of semen, injury, or other physical evidence.
Okay, source of physical evidence.
Or specific instances of sexual behavior between the victim and the accused if offered by the defendant to prove consent or if offered by the prosecutor.
Behavior with the accused for consent.
And finally, evidence whose exclusion would violate the defendant's constitutional rights, like the right to confrontation or to present a defense. Very high bar there.
What about civil cases? Is it different?
It is. In civil cases under FRE 412b2, evidence of the victim's sexual behavior or predisposition is admissible only if its probative value substantially outweighs the danger of harm to the victim and unfair prejudice to any party. Notice that reversed and heightened balancing test probative value must substantially outweigh the harm.
Much harder standard in civil cases.
Yes, and evidence of the victim's reputation regarding sexual behavior is admissible in civil cases only if the victim has put it into controversy themselves.
Okay. The notes also mention procedural stuff like notice and hearings for this type of evidence.
Right. There are specific procedures involving motions, notice, and usually in-camera hearings to determine admissibility before the jury hears anything.
Now, what about the flip side? Evidence of the defendant's prior sexual misconduct in these cases.
This is where the rules take a sharp turn away from the general character evidence ban. FRE 413, 414, and 415 address this.
What do they say?
In criminal cases involving sexual assault, 413, or child molestation, 414, and in civil cases involving such conduct, 415, evidence that the defendant committed any other sexual assault or child molestation is admissible.
Admissible for what purpose? Propensity.
Yes. That's the huge change. The notes state this evidence is admissible to show the defendant's propensity to commit such acts or for any other relevant purpose. It's a specific exception carved out for these types of offenses, allowing propensity evidence against the defendant based on similar prior acts.
Wow, that's a major departure from FRE 404. Is it still subject to Rule 403 balancing?
Yes, the notes indicate it's still subject to 403 balancing, though how that balancing works in conjunction with these specific rules can be complex, maybe interacting with the standards for prior convictions under Rule 609. But the key takeaway is propensity is on the table here.
Okay, specific exception for propensity evidence of defendants' similar acts in sexual misconduct cases. Got it. Let's move to witnesses themselves. Competency.
Generally, under FRE 601, witnesses are presumed competent. The bar is low, basically. Understand the duty to tell the truth and be able to perceive, remember, and communicate.
What's a core requirement for a lay witness, someone not testifying as an expert?
Personal knowledge, FRE 602. They have to testify based on what they saw, heard, or otherwise sensed themselves. Their opinions also have to be based on their own perception. Experts are different. They don't necessarily need personal knowledge of the specific events.
We talked about jurors not testifying. What about dead man acts? Do those apply in federal court?
Ah, the Dead Man Acts, classic bar trap. These are state laws preventing interested parties from testifying about conversations or transactions with someone who is now deceased when suing the estate. The key point from the notes, there is no federal Dead Man Act.
No FRE Dead Man Act.
Correct. However, Erie applies again. If it's a diversity case in federal court where state law governs the claim, then the federal court will apply the state's Dead Man Act.
So only worry about it if the question explicitly puts you in a state law diversity context.
Exactly. The notes have a hypo. Shania sues Elvis's estate. Shania's testimony about talking to Elvis might be barred by a state Dead Man Act, if applicable. But her friend Faith, who just overheard it, wouldn't be barred because Faith isn't an interested party suing the estate.
Got it. State law only. Okay. When can a regular lay witness give an opinion? FRE 701.
Lay opinions are okay if three things are true, according to the notes. One, it's rationally based on the witness's own perception, what they saw heard. Two, it's helpful to the jury in understanding the testimony or determining a fact. And three, crucially, it's not based on scientific, technical, or specialized knowledge that's expert territory.
So common sense inferences from their own observations. What are some examples?
The notes mention things like identifying handwriting they're familiar with. Also common are opinions about someone's general appearance or emotional state, speed of a car, voice identification, whether someone seemed intoxicated, or the value of their own property or services, things most people can form a reasonable opinion on from observation.
Okay. What if a witness is on the stand and just blanks? Can't remember something.
That's refreshing recollection, FRE 612. You can show the witness pretty much anything, a document, a photo, an object, to try and jog their memory.
And then that document you showed them comes into evidence.
No, this is a super important distinction the notes stress. The item used to refresh is not admitted into evidence by the party doing the refreshing. The witness looks at it, hopefully remembers, and then testifies from their now refreshed memory.
How's that different from past recollection recorded? They sound similar.
Key difference. Refreshing means, okay, now I remember, and they testify from present memory. Past recollection recorded, that's a hearsay exception, FRE 803-5, is when, even after looking at the document, the witness still can't remember fully.
Still drawing a blank.
Right. In that situation, if the document meets the requirements, made adopted by witness when memory fresh accurately reflects knowledge, the document itself can be admitted as substantive evidence. The notes mentioned it's typically read into evidence rather than given to the jury as an exhibit, unless the adverse party offers it. The notes contrast this with a police officer using a transcript to refresh memory that's refreshing, because the officer then testified from memory.
Refreshing. I remember now. Past recollection recorded. I still don't read the document.
Got it.
What race does the other side have when you use something to refresh memory?
If you use it while the witness is testifying, the adverse party has an absolute right to inspect it, cross-examine the witness about it, and introduce relevant parts into evidence. If you used it before the witness testified, the judge has discretion to allow inspection if justice requires.
Fair enough. Prevents ambushes. Okay,
Right.
let's get into attacking witness credibility impeachment.
Right. Challenging a witness's truthfulness or accuracy. The notes cover several methods.
Starting with prior inconsistent statements. FRE 613.
Yep. Showing the witness said something different before than what they're saying now on the stand.
Are these prior statements used to prove the truth of what was said before?
Usually no, and this is critical. Traditionally, prior inconsistent statements are only admissible for impeachment just to show the witness is unreliable because they changed their story. However, the notes stress FRE 801D1A. If the prior inconsistent statement was made under oath at a prior proceeding, trial, hearing, deposition, it's defined as not hearsay.
Not hearsay, so it can be used
For its truth. These sworn prior inconsistent statements are admissible as substantive evidence A and D for impeachment. The notes use an example. A witness told police the defendant sold drugs, but denies it on the stand. That statement to police is only for impeachment, unless another rule applies. But if they had said it under oath at a grand jury, it could be used to prove the defendant sold drugs and to impeach.
Okay, sworn prior inconsistent statements get double duty. Unsworn ones usually just impeach. Do you have to show the statement to the witness first?
FRE 613A says generally no, not while examining them, but you must show it to opposing counsel on request. And FRE 613B generally requires giving the witness an opportunity to explain or deny the statement, and the adverse party a chance to question them about it, though this doesn't always have to happen before introducing extrinsic evidence of the statement.
Got it. What about showing a witness is biased?
Bias impeachment is always relevant. Showing the witness has some motive to lie or shade their testimonial relationship with a party, financial interest, past fights, etc.
Can you bring in outside evidence to prove bias?
Yes, extrinsic evidence of bias is permissible. Courts often prefer you ask the witness about the bias first, lay a foundation. But the notes say just proving a relationship, family, employment, can be enough foundation. Bias affects the weight the jury gives the testimony.
Bias is always relevant. Extrinsic evidence allowed. Okay, how about using prior criminal convictions? FRE 609.
609. Heavily tested. You can use certain prior criminal convictions to attack a witness's character for truthfulness. But the rules are specific.
What's the first big category?
Crimes involving dishonesty or false statement. Any crime, felony, or misdemeanor that required proving an act of dishonesty or false statement, like perjury, fraud, embezzlement, generally must be admitted for impeachment against any witness. These are seen as directly relevant to truthfulness. There's some limited 403 balancing possible for witnesses other than a criminal defendant.
Okay, dishonesty crimes are almost automatic. What about felonies that don't involve dishonesty, like assault or robbery?
For those felonies, punishable by death or 1 year, admissibility depends on who the witness is.
If it's the criminal defendant testifying.
Then the conviction comes in only if the prosecution shows its probative value for truthfulness outweighs its prejudicial effect to the defendant. The notes emphasize this is a stricter test, favoring exclusion for the defendant. The assault conviction example fits here, likely too prejudicial.
Stricter test for defendant. What if the witness is just a regular witness, not the defendant?
For any other witness, a non-dishonesty felony comes in, unless the party opposing it shows its probative value is substantially outweighed by unfair prejudice. That's the standard Rule 403 balancing, which favors admission more.
Okay, easier to get non-dishonesty felonies in against witnesses who aren't the defendant. Is there a time limit on these convictions?
Yes, the 10-year rule. Generally, if more than 10 years have passed since the conviction or release from confinement, whichever is later, the conviction is inadmissible. Unless the proponent convinces the judge that the probative value substantially outweighs the prejudicial effect, an even tougher standard, and gives reasonable written notice to the other side. So old convictions are very hard to get in.
Okay. Can you prove the conviction with, the court record?
Yes. Extrinsic evidence, the record of judgment, is allowed. You don't need to ask the witness first. And the notes clarify. Misdemeanors not involving dishonesty are not admissible under Rule 609 at all.
Got it. What about using bad acts that didn't result in a conviction, like lying on a job application? FRE 608B.
Right? Specific instances of conduct that are probative of truthfulness or untruthfulness, but didn't lead to a conviction, can be inquired into on cross-examination of the witness.
But what's the huge limitation here?
Extrinsic evidence. The notes hammer this home. You cannot introduce extrinsic evidence, other witnesses, documents, to prove the specific bad act occurred if the witness denies it on cross. You ask the question, you're generally stuck with their answer.
The food stamp application example.
Exactly. You can ask the witness on cross, didn't you lie on your food stamp application last year? Assuming it's probative of truthfulness. But if they say, no, I didn't, you cannot call the welfare agent or offer the application to prove they lied.
Ask, but can't prove with outside evidence.
Yeah.
Prevents many trials.
Precisely. Rule 608 also covers reputation or opinion testimony about a witness's character for truthfulness. You can only introduce evidence of their good character for truthfulness, bolstering, after their character for truthfulness has been attacked. You can't bring it up preemptively.
So if they attack my witness as a liar, I can bring someone in to say they're known as honest.
Yes. And the notes mention one more impeachment method. Attacking the witness's capacity, their ability to perceive, recall, or relate accurately. You can use cross-exam or extrinsic evidence to show things like bad eyesight, hearing problems, memory issues from an injury, or intoxication at the time of the event.
Makes sense if they couldn't see it clearly, their testimony is less reliable. What if the person being impeached is a hearsay declarant, someone whose out-of-court statement came in?
FRE 806 covers that. You can attack the credibility of hearsay declarants using any method you could use if they were testifying live, prior inconsistent statements, bias, convictions, bad acts, etc. The notes point out a key difference. You don't need to give the hearsay declarant, who isn't there, an opportunity to explain or deny things like inconsistencies or bias.
Okay, same impeachment tools apply to the unseen hearsay declarant. How do you fix a witness's credibility after it's been attacked? Rehabilitation.
Rehabilitation is about restoring credibility. You can let the witness explain the inconsistency or alleged bias on redirect. A powerful tool is prior consistent statements.
When can you use those?
To rehabilitate, they generally need to have been made before the alleged inconsistent statement or before the motive to fabricate arose. Crucially, under FRE 801D way, a prior consistent statement offered to rebut a charge of recent fabrication or improper motive and made before the motive arose is not hearsay. It comes in for its substantive truth and for rehabilitation.
So showing they said the same thing before they had a reason to lie is really strong.
Very strong. And you can also use reputation or opinion evidence for truthfulness to rehabilitate, but again, only after their character for truthfulness has been attacked.
Phew, that's a lot on witnesses and impeachment. Okay, shifting gears to physical evidence. Authentication and the best evidence rule.
Authentication first, FRE 901. Before you can admit an item of evidence, you have to show sufficient proof that the item is what you claim it is. The notes stress this is a low bar, just enough evidence for a reasonable juror to find it's authentic.
How do you authenticate things? What methods do the notes mention?
Lots of ways. Testimony from a witness with personal knowledge? Yes, that's the knife I saw. Chain of custody for items that aren't unique or could be tampered with, tracing it from crime scene to courtroom.
Okay.
Voice ID. Anyone who has heard the voice, even just for litigation purposes. Phone calls. Recognize the voice. Caller. Knew unique facts. Called a listed number. Called a business and talked business.
Photos and videos.
Authenticated by any witness with knowledge who says it's a fair and accurate depiction. The notes emphasize the photographer isn't required. They use an example of authenticating a printout from a video, even if the video is gone.
Just need someone to say, yep, that's what it looked like. Documents.
Can be authenticated by comparison with a known genuine sample by expert or jury. The notes have a forgery example. Reply letter doctrine. If a letter looks like a reply to one you send, it authenticates itself to some extent. Ancient documents. 20-plus years old, unsuspicious condition, found in a likely place. Notes distinguish this 20-year rule from the pre-1998 ancient documents hearsay exception. Tape recordings need proof of the device working, operator competency, preservation.
Okay. Are there things that authenticate themselves?
Yes, self-authentication under FRE 902. Certain documents are presumed authentic. Key examples from the notes. Official public documents under seal, certified copies of business records with notice, commercial paper, like checks, newspapers and periodicals. Self-authenticating as publications, not necessarily for the truth of contents.
Streamlines things for reliable documents. Okay, now the best evidence rule, or original document rule.
FRE 1001-1008. This rule applies only when you're trying to prove the content of a writing, recording, or photograph. If content itself is what matters, the rule generally requires you to use the original.
Only when proving the content. This is the big trap, right?
Yeah, huge trap. The notes really stress this. The rule is not triggered just because a document exists or is relevant. It's only triggered if you're trying to prove what the document says or what the photo shows. The examples are key. Proving a bank was insured doesn't require the original policy, just proving the fact of insurance. The officer refreshing memory with a transcript, not proving the transcript's contents.
Always ask, am I trying to prove what this thing says?
Exactly. If yes, the rule applies and you generally need the original. But FRE 1004 lists exceptions where secondary evidence, like a copy or testimony, is okay. The notes list them. Original lost or destroyed, not in bad faith. Original unobtainable by court process, opponent has original and won't produce it after notice, or the document is collateral, not central to the case. No hierarchy among secondary evidence.
Okay, exceptions allow copies or testimony. What about duplicates, like photocopies?
FRE 1003 says, duplicates are generally admissible just like originals, unless there's a genuine question about the original's authenticity, or it would be unfair. Usually copies are fine. Prints from negatives are considered originals.
Public records.
FRE 1005 allows certified copies of public records. If you can't get one diligently, other evidence is okay.
What if you have mountains of documents, like financial records?
FRE 1006 allows summaries. You can use a summary, chart, or calculation to prove the content of voluminous writings, recordings, or photos that can't be conveniently examined in court. But the crucial catch the notes highlight. The underlying originals or duplicates must be made available for the other side to examine or copy. No access, no summary admitted.
Summary is okay if the backup is available. Lastly here, rule of completeness.
FRE 106. If one party introduces part of a writing or recorded statement, the adverse party can require them to immediately introduce any other part or any related writing statement that, in fairness, should be considered at the same time. To prevent misleading impressions from taking things out of context, it allows immediate context rather than waiting for cross-exam. The notes point out it can even override a hearsay objection to get the completing part in for fairness. There's some debate if it makes inadmissible evidence admissible or just controls timing, but fairness is the key.
Powerful rule for context. Okay, that handles documents. And now, the big one, hearsay.
Hearsay, everyone's favorite. The definition in FRE 801 is the starting point. An out-of-court statement offered in court to prove the truth of the matter, asserted in the statement.
Made outside this court proceeding, offered to prove what it says is true. Why is it generally inadmissible?
Reliability concerns. The person who made the statement, the declarant, wasn't under oath then and isn't subject to cross-examination now about that specific statement. We can't test their sincerity, perception, memory, narration right then and there.
Okay. Out-of-court statement plus offered for its truth, hearsay, generally inadmissible.
That's the basic flow. And a key tip from the notes. Even if a statement seems to fit a hearsay exception or exclusion, don't stop there. Always check basic relevance, 401, and unfair prejudice, 403. Passing the hearsay test doesn't guarantee admissibility.
Good point. Rules interact. Okay, first, statements that look like hearsay but are defined as not hearsay under FRE 801D, exclusions.
Right. The rules consider these reliable enough or offered for a different purpose. First category, certain prior statements made by someone who is now testifying and subject to cross-examination about the prior statement.
Like the prior inconsistent statements we talked about for impeachment.
Exactly. Under 801D, a prior inconsistent statement is not hearsay if it was made under oath at a prior proceeding, trial, hearing, depot. Admissible for its truth and impeachment, otherwise generally just for impeachment.
Okay. What else in this category?
Prior consistent statements, 801D, 1B. Not hearsay if offered to rebut a charge of recent fabrication or improper motive and made before the motive arose. Also admissible for truth and rehabilitation.
And prior identifications.
Yes, 801DP. A prior statement identifying someone the witness perceived earlier is not hearsay if the witness testifies and is subject to cross about it. The notes had the example of the witness identifying someone in a photo array, but for getting at trial, the prior ID still comes in because the witness is there for cross. But if the witness refuses to testify, no cross, so the prior ID is hearsay.
Okay, for a testifying witness, sworn inconsistent, pre-motive consistent, and prior IDs are defined out of hearsay. What's the other big 801D exclusion category?
Opposing party statements, often called admissions by party opponent, under 801.2. A statement is not hearsay if it's offered against an opposing party and was made by
the party themselves.
Yes, the party individually or as a representative, or by someone the party authorized to speak, or by the party's agent or employee about something within the scope of their agency employment and while it existed, or by a co-conspirator during and in furtherance of the conspiracy.
So basically anything the other side said, or their authorized people, agents, co-conspirators said, can be used against them.
Pretty much. The notes stress the agent-employee part. Statement must be about their job duties and made while employed. The truck driver fired before making the statement. Inadmissible against the company under this rule. The repair guy driving on personal time. Statement likely outside scope.
Got it. Scope and timing matter for agents. What about adoptive admissions?
That's under 801.10.2 too. When a party manifests belief in someone else's statement, maybe by nodding, repeating it, acting on it, or even sometimes by silence when a reasonable person would have denied it, the notes contrast this with silence being meaningless if there was no reason to respond.
The idea seems to be the party can explain their own statements now in court.
That's part of the rationale. The notes also mention statements with independent legal significance, operative facts, aren't hearsay because you're not offering them for their truth, but just to prove the words were said, like I accept in contract law or defamatory words.
Okay, those are the major exclusions from the hearsay definition. Now for the exceptions, statements that are hearsay but are admissible anyway. First, the FRE 803 exceptions, where it doesn't matter if the declarant is available or not.
Right, these are deemed reliable enough on their own. First, present sense impression. 803 other. Statement describing or explaining an event while perceiving it or immediately after. Contemporaneousness is key. The notes had the example of the call about men near a truck being too delayed.
He's turning left now, right as it happens.
Exactly. Second, excited utterance, 803.2. Statement relating to a startling event made while the declarant was still under the stress of the excitement caused by it. The notes use the person hit by a car yelling, "He hit me," needs startling event plus stress. Relates to the event, not just describes it.
Stress versus immediacy.
Third, statement of then existing mental, emotional, or physical condition. 803. declarant's state of mind, intent, plan, motive, or physical feeling, pain, health. At the time they made the statement, "My back hurts. I plan to go to Vegas," generally can't be used to prove a past fact or someone else's state of mind.
Okay. What about statements to doctors?
Fourth, statement made for medical diagnosis or treatment, 8030. Statements about medical history, past or present symptoms, pain, or their general cause, if made for getting diagnosis or treatment. Include statements about how an injury happened if it's pertinent to treatment.
Makes sense. People are usually truthful when seeking medical help.
Fifth, past recollection recorded. We covered this, the record made by a witness who now can't remember, made when memory was fresh, accurately reflects knowledge. Read into evidence not usually received as exhibit unless by opponent.
Right. Business records.
Sixth, records of regularly conducted activity. Huge exception. Records, memos, reports, data of acts, events, opinions, diagnoses kept in the course of a regularly conducted business activity made near the time by someone with knowledge or from info transmitted by someone with knowledge if it was the regular practice to make such records. Needs foundation from custodian or certification. Notes say exec's personal notes don't count. Hospital records often do. Trustworthiness caveat applies, can be excluded if source or method seems unreliable.
Regular, timely, routine business records, unless fishy.
Exactly. Seventh, absence of a record. Showing something isn't in the records to prove it didn't happen if it was the type of thing normally recorded. Notes used missed medication on a hospital chart.
Public records.
Eighth, public records. 803. Records of public agencies about their activities or matters they observed under a legal duty, but not police observations in criminal cases under this exception, or factual findings from legally authorized investigations, admissible against government in criminal cases and in civil cases. Vital stats, too. Notes highlight the police report issue. Officers' observations might fit, but bystander statements within the report need their own exception. Fire marshal report findings. Again, civil. Trustworthiness caveat again.
Police observations in criminal cases excluded here is a big one.
Very important. 10th, absence of public record, 803. Similar to the business record showing diligent search failed to find record proves non-existence. Notes mention jail records example.
Learned treatises.
18th, learned treatises. Statements from authoritative books or articles. Key points from notes. Must establish reliability. Expert testimony, judicial notice. Can only be read into evidence, not received as exhibit, and must be used with an expert on the stand to explain apply it.
Read it. Don't give the book to the jury. Any other quick 803s?
Notes mention record statements and documents affecting property interests, 803, 14, and 15. Yeah. Family records like Bible tombstones, 803, 13. Market reports, commercial publications, 803, 17.
And the catch-all.
The residual exception, 807. For trustworthy hearsay not fitting elsewhere, needs equivalent guarantees of trustworthiness, materiality, necessity, more probative than other available evidence, serves justice, and requires notice. Notes had the co-defendant's letter to boyfriend example. Use sparingly.
Okay, those are the 803 exceptions. Availability doesn't matter. Now, the FRE 804 exceptions, which require the declarant to be unavailable.
Right. First, you have to establish unavailability under 804A, privilege, refuses to testify, lack of memory, death, illness, absent and beyond reach of process.
Declarant genuinely unavailable. Then what exceptions apply?
First, former testimony, 804B1, testimony from a prior trial, hearing, or deposition, now offered against a party who had, or in civil cases, whose predecessor in interest had, an opportunity and similar motive to develop that testimony before direct, cross, redirect.
They had their shot at the witness on that topic before.
Exactly. Second, statement under belief of imminent death, dying declaration, 804B2. In homicide cases or any civil case, statement by unavailable declarant made while believing death was imminent about the cause or circumstances of that believed impending death. Declarant doesn't have to actually die, must be based on personal knowledge. Notes had the car accident victim's statement about who ran the light.
Homicide civil only, believed death near, about pause circumstances.
Yes. Third, statement against interest, 804B3. Statement that a reasonable person wouldn't have made unless true because it was so against their pecuniary, money, proprietary property, or penal criminal liability interest when made. Declarant must be unavailable. For statements exposing declarant to criminal liability need corroborating circumstances indicating trustworthiness. Notes distinguish this from party admissions. Declarant need not be party, must be unavailable, must be against interest.
Different requirements than party admission?
Very different. Fourth, statement of personal or family history, 804B4. Statements about declarant's own family history, birth, marriage, etc., or someone they were related close to. Admissible even if declarant lacked personal knowledge of their own history.
Okay, those need unavailability. What about hearsay within hearsay, like a document containing a quote?
Multiple hearsay, FRE 805. If hearsay includes other hearsay, each level needs an independent exception or exclusion to be admissible. Notes use the police report public record containing a bystander quote, excited utterance. Both need to qualify. Or the wife testifying about a husband's statement about a threat double hearsay. Each link needs a basis.
Trace each layer back. Got it. That covers the rules, but there's a constitutional overlay in criminal cases, right? Confrontation clause.
Yes, Sixth Amendment. Guarantees criminal defendant the right to confront witnesses against them face-to-face, cross-examination. This impacts hearsay. The Supreme Court in Crawford said this right primarily applies to testimonial out-of-court statements offered against the accused.
What's testimonial?
Notes explain it generally means statements made under circumstances where an objective witness would realize the statement would likely be used later at trial. Think formal statements to police, affidavits, prior testimony. Testimonial hearsay against a criminal defendant is barred unless the declarant is unavailable and the defendant had a prior opportunity to cross-examine them about that statement.
So even if it fits a hearsay exception, the confrontation clause blocks it if it's testimonial and there was no prior cross.
Exactly. Crawford can override hearsay exceptions for testimonial statements in criminal cases.
What's not testimonial, usually?
Statements made primarily to help police respond to an ongoing emergency. The main purpose isn't creating trial evidence, but resolving a present danger. Notes mention factors like nature of dispute, suspect at large, scope of threat, weapons. A frantic 911 call during a crisis is usually okay. A calm station house interview later is usually testimonial.
Okay, emergency exception. What about lab reports?
Notes say things like drug analysis reports are generally testimonial created for prosecution. Also notes that a defendant can forfeit their confrontation clause rights by wrongdoing intended to keep the witness away.
Can't silence a witness and then complain about not confronting them. Due process.
Notes mention briefly that evidence rules can't be applied so rigidly that they deny the accused a fair trial or the right to present a defense. Compulsory process.
Okay. Hearsay and confrontation covered. Last big area. Privileges.
Privileges. Rules allowing someone to refuse to disclose confidential info. FRE 501 says in federal court, privileges are governed by federal common law, unless Constitution Statute SCOTUS rule says otherwise.
Except
Erie. Notes stress this bar exam point again. In civil cases, based on state law, diversity, state privilege law applies. Otherwise, federal question cases use federal common law privileges.
State law for privilege and diversity. Got it. What are the main federal common law privileges from the notes?
Spousal privileges first. Two distinct ones. Spousal testimonial privilege. Applies only in criminal cases. Allows a spouse to refuse to testify against their current spouse about anything. The witness spouse holds this privilege, only applies if married at time of testimony. Notes had the wife refusing to testify about husband's clothes in theft case.
Okay, criminal only, witness holds any info during marriage. What's the other one?
Marital communications privilege. Protects confidential communications made between spouses during a valid marriage. Applies in civil and criminal. Both spouses hold it, either can prevent disclosure, survives divorce, but only protects communications made while married, doesn't apply to communications about future crimes, fraud, or in suits between the spouses.
Confidential communications during marriage both hold survives marriage. Got it. Attorney-client.
Protects confidential communications between client and attorney, or reps, for purpose of legal advice services. Confidential means not intended for disclosure to unnecessary third parties. Notes mention accountant example privileged if accountant is attorney's agent. Maybe not if client just asks accountant's opinion.
Client holds it, survives death.
Yes. Applies inside and outside litigation. Exceptions noted. Communications furthering future crime fraud are not privileged. Disputes between former joint clients about the joint representation, no privilege between them for those communications.
What about accidental disclosure?
FRE 502 provides protection. Inadvertent disclosure doesn't waive if holder took reasonable steps to prevent it and promptly tries to rectify it. Waiver usually limited to disclosed info, not whole subject matter, unless intentional.
Reasonable steps save you. Fees, demeanor.
Notes say client's appearance generally not privileged. Fee info usually not privileged, unless revealing it reveals the confidential communication itself. Notes had tax evasion fee example amount admissible. Briefly mentioned shareholder exception allowing them to overcome privilege sometimes.
Okay. How is work product different?
Work product doctrine protects materials, docs, things, prepared in anticipation of litigation. Attorney-client protects communications for legal advice anytime. Work product protects scuff only for litigation prep. Notes use will drafting. AC applies, WP does not.
AC equals communication. WP equals litigation materials.
Right. Purpose is to protect lawyers' mental process. Ordinary WP, witness statements, discoverable on showing need hardship. Opinion WP, lawyers' thoughts, theories, almost absolutely protected. Notes head, accident report for lawyer, example could be both.
Physician-patient privilege.
Protects confidential patient-doctor comms for diagnosis and
right.
treatment. But the huge point from the notes, generally not recognized under federal common law, no FRE rule, but POER, Erie applies, federal courts apply state physician-patient privilege in diversity cases.
No federal privilege, but apply state rule in diversity. Critical point.
Absolutely. Notes say doesn't cover comms for litigation prep, ends if patient's condition is at issue.
Other privileges mentioned.
Notes briefly list others potentially recognized. Psychotherapist, patient, clergy, penitent, government privileges. Depends on jurisdiction or common law development.
Wow. That was a whirlwind tour through evidence based on Angela's notes. Relevancy, witnesses, impeachment documents, hearsay, privileges, everything.
It really shows how interconnected it all is. Understanding hearsay exceptions requires knowing about impeachment. Relevance rules apply everywhere. It's a web.
Definitely. And reviewing the notes like this highlights some recurring themes and traps for exams.
For sure. Key takeaways popping out from the review. Always default to FRE, but watch for state law, especially privileges and diversity. Beware old common law traps.
Best evidence rule only applies if you're proving the content. That's huge.
Judges' discretion on trial management is broad unless a specific rule limits it.
Hearsay analysis. Out of court. For truth. If yes, exclusion 801T. Exception 803, 804. Still check 401, 403.
Privileges. Identify relationship purpose. Remember, Fed versus state law split. No AC versus work product.
Character versus habit. Know the difference and the general ban on propensity with its specific exceptions. MIMAC 413, 415.
Impeachment. Know the conviction rules, 609, bad act rules, 608B, especially no extrinsic evidence for 608B, bad act.
Criminal presumptions must be permissive, not mandatory.
Confrontation clause. Is statement testimonial? Was there prior cross-exam ob? Key for criminal cases.
Those are excellent summaries of the big pressure points. It really feels like evidence is about spotting the issue, knowing the precise rule, and often understanding the policy behind it.
It absolutely is. And these notes show the level of detail required. Even after this review, it's clear evidence demands really careful study.
Couldn't agree more. It definitely rewards that close attention.
Yep.
Well, thank you again, Angela, for your amazing evidence notes. They made this deep dive possible, and that's officially a wrap on evidence for us.
It is. And next up, drum roll. Torts, everyone's favorite. Who doesn't love exploring negligence?
Oh, the world of duty, breach, causation, damages. Can't wait. We'll tackle that next time. But first, just a couple of quick housekeeping points.
Yeah, some important reminders for everyone listening.
First, please remember, Angela is a law student, just like many of you. She's not a licensed attorney or bar-certified expert yet. These are her study notes we're working from.
And second, crucially, neither Angela nor us AI bots are giving legal advice here. Nothing in this deep dive should be taken as legal advice. AI is a tool, but it's absolutely not a substitute for your own study, checking primary sources and getting advice from qualified lawyers.
Definitely. And third, AI isn't infallible. Sometimes we might make mistakes in how we process or present information. Angela does try to correct errors in her notes, but always verify rules and concepts yourself.
Good advice. And one more time, that contact info. If you're an attorney or know one needing freelance help with motions, briefs, research, etc., you can email Angela at hello@legalwriterandlawclerk.com.
Okay, before we completely sign off, podcast tradition dictates a law joke.
Oh boy. All right, let's have it.
Why did the Scarecrow win an award?
I feel like I should know this. Why?
Because he was outstanding in his field.
Yes,
Yeah.
outstanding.
Hey, it's tradition.
It is, it is.
Okay, as we close out this deep dive, here's a final thought. We talked a lot about rules, exceptions, balancing tests. But so much seems to come down to judicial discretion and the specific facts. How much of mastering evidence is memorizing rules versus developing that gut feeling, that practical sense for how judges actually apply these rules in a real messy trial? Something to think about.
That's a great question to ponder as you study.
This is Claude and Ma, your AI bot, signing off from this evidence deep dive.
We'll see you on the next deep dive.
Goodbye, and thank you for listening.
Goodbye, everyone. Thanks.